Hey folks, I'm attorney Roger P. Foley, just arriving home for the evening. But I wanted to tell you, before I even walk into my house and greet my family, I wanted to tell you about one of the most serious cases I've had that's lasted almost a year and a half now. And today it finally came to a conclusion. I had a gentleman that was charged with armed burglary of a dwelling, aggravated stalking, and sending threatening text messages to kill. He was facing life in prison with a minimum 10-year sentence on the armed burglary. The gist of the story, what the police report says: defendant and his ex-girlfriend are fighting. They're having, they break up. He starts sending harassing text messages over a few weeks' time. One particular night, they're going back and forth. She's saying, "Don't contact me. I don't want to have anything to do with you." He's trying to convince her otherwise. And ultimately, he says to her, "I'm going to come to your house, and I'm going to kill you, and then I'm going to kill myself." She then contacts police. Police show up at the house. He doesn't arrive. And the police say, "Hey, it's probably safer for you to get a hotel room." So she goes and gets a hotel room with her family. Comes back the next day. She's still feeling unsafe. She calls the police and says, "Can you check out my house? I want to make sure that he's not hiding in my house. I know my ex-boyfriend has a concealed firearms permit. I know he carries firearms daily." They come, they check out the house. He's not there. She receives one more text in the afternoon. Not sure if she even sees it, or I think she sees it after the fact. And she's outside in the garage and she's washing clothes. As she goes to close the garage, she sees her ex-boyfriend approaching and she says, "Get away, I told you I don't want to see you." And she goes to close the garage and he basically kind of dives under the garage. Not dives, but slips under the garage door before it closes. He says to her something to the effect of, and this is all in the police report, all public record, folks, not divulging any confidential information. He goes under the garage door and says, "Hey, honey, can we work it out?" And she goes, "Absolutely not. I'm done with you." And he says, "Okay." He has a bag. He takes it off of his shoulder, puts it on the ground, and he says, "Now you're going to watch me kill myself." And as he starts to go into the bag, where she believes that he has guns, she runs into the house, locks the door behind her, gets her family, and flees the home. She calls the police, a 911 call, very scared, saying, he's back. He's got guns. And the dispatcher's asking, "Does he have guns?" And she goes, yes, he has guns." "Did you see the guns?" "Well, no, didn't see the guns." However, she knows he has guns. Police come, lots of police, and they search the house. Now she's hiding down the street, behind a house, behind a home, behind buildings, bushes, and the police come. And there's so many police officers. One finds her, puts her and her family in the back of the police car, has them stay down, and he's outside, his car with a weapon. He stands a little off just in case the individual comes, that he can shoot them. Police officers arrive at the woman's home. They search the house. They don't find him. So they put a bolo out, a be on the lookout for this person, and a general description. When they set up a bolo, they set up a perimeter, right? A certain area. Let's say it's a half a mile, right? A round radius. Not in that radius. Another officer is sort of driving outside the perimeter of where it was set up, and he comes across an individual who he thinks fits the bolo. Ultimately, it tends to be the same individual. Ultimately becomes my client, and he is detained. He is searched, and the two firearms, Glock 9 and some other firearm that I'm not even sure what it is recovered. Magazine inside the gun. One of the guns was locked and loaded. Another was in a box. So he's arrested. Armed burglary, aggravated stalking, and sending threats by messages. So just so you know, sending threats in Florida to kill. I'm going to come kill you. That's a second-degree felony, punishable by up to 15 years Florida State Prison. Aggravated stalking, third-degree felony, punishable by up to 5 years Florida State Prison. Armed burglary, first-degree felony. Right? So you have the armed burglary mixed with the stalking, and that becomes a life felony. So he was facing life with a minimum mandatory of 10. So got together with another attorney on this case, and we worked the case. I also had another attorney friend of mine from out of state come in and help me do something what's called psychodrama. It's kind of like mock trials, and we call them focus groups. We're not doing all the legalese of a cross-examination and a direct and having a fake judge. We're basically giving the individuals in the participants, in this case about 150 students, we did it 3 times, probably 50 to 100 students each time, and we go through the facts and we present the facts in different ways to find out what regular people, average citizens would think, because these are the type of folks that you're going to have in your voir dire, in your jury selection. So this case took a lot of time. The last 14 months of my life, I've spent a lot of time on this case. I showed the state attorney some flaws in the case, and they were willing to go 5 years Florida State Prison, followed by 10 years of probation, convictions across the board, so he'd be a convicted felon, and if he violated, he would be facing life in prison. So if he missed his probation appointment or didn't stay on house arrest or picked up even a traffic criminal like driving with a suspended license, he would be potentially facing life on this domestic violence case. Well, we weren't going to do that. We thought that we had the facts to win on the armed burglary and on the aggravated stalking. The second-degree felony of sending threats to kill, we couldn't figure out a way really to win that case. I probably had less than a 10% chance of winning that. So as we contemplated the best ways to handle this case and to propose it to a jury and to defend it, one of the big arguments is armed burglary. Just so you know, folks, the definition of burglary, I'm going to be a little detailed, is the entering of a premises with the intent to commit a crime. The state's argument is the guy sent her a message the day before. It says, I'm coming to kill you and kill myself. His intent is to come there and kill, part of the stalking, and he had sent text messages over 2 weeks. When he got there and he entered the garage, they're saying that his intent therein was to kill her. However, our argument was when he got there, he didn't say, I'm going to kill you now and then kill myself. He said, you're going to watch me kill myself. So what is the crime therein? The state was trying to argue that the crime therein was stalking or perhaps murder. He never shot the gun. She never saw the gun. He never chased her, didn't shoot into the house. There was no discharge of the firearm. He just disappeared and she was running and hiding somewhere out in the neighborhood. So we thought that we had a great chance on the burglary. We didn't even see it as a burglary, let alone an armed burglary, right? Having a firearm, because she never saw any weapons. Even though the weapons were found in his possession, but that might have been, 40 minutes later. Again, all this is in a very long, detailed police report with follow-up documents. So we felt very confident on that. On the stalking, focus groups revealed a lot to us, that even though that these were these serious messages of threats to kill and suicidal threats, that generally the participants thought that this person was actively involved, sort of like egging them on, giving them a little bit of basically putting a little bit of gasoline on the fire, going back and forth. They believed that if someone was truly stalked, that they wouldn't respond, that they would be scared, they would run. They wouldn't say, some of the things that were said. They wouldn't feed the fire, so to speak. Additionally, we didn't think, even though the state's argument was that the text messages happened over the 2 weeks, we had a compilation of texts, but they weren't consecutive in time. We didn't have on Monday, January 1st, this happened. Then on January 5th, there was nothing consecutive. They were just sort of all scrambled. So we were trying to figure out when it came. Really, the messages that were received in discovery, although they said they were over a 2-week pattern, really happened the day before. So you had a time lapse in between when he said, "I'm coming to kill you," and when he came there. And the argument that was going to be proposed is there's a time period there. When he got there to the house, he had time to cool off. So there was a space and time, a cool off period, a time where he could, go over his own thoughts and say, "Hey, no, I just want to make up with the girl. I'm not trying to kill her." And there was, we thought that there was sufficient argument to win. We thought, right, that on the first count of armed burglary, that more than likely it would be a lesser included charge of trespass. So we go from a first degree felony of facing 30 years to a misdemeanor facing 1 year. So we said, okay, if we lost on that, this judge would more than likely give him a year. On the aggravated stalking, we said, we don't really see it as aggravated stalking. We're not even sure if it's stalking. We thought we were looking at possibly a stalking, so a misdemeanor, first degree misdemeanor. That's punishable by a year. So the judge could either give him a second year, consecutive sentences, or he could give him a year concurrent where he just does 1 year for both. However, the third count, the written threats to do bodily harm and to kill, that's a second degree felony. We thought that our chances were less than 10% to win that. Preparing for trial, prosecutors change. I explained a lot of my defenses, obviously not all of my defenses. You always got to keep a couple tricks in the hat. But I explained several of the weaknesses to the prosecutor, the prosecutor's supervisor, and then ultimately they explained it to even their upper supervisor. And ultimately, the defendant is going to be released today or possibly tomorrow. The sentence, again, all public record, is 1 year of community control, which means house arrest. Can't leave your house. You have a GPS monitor, you can't leave. Followed by 5 years of probation, where he's also going to have a GPS monitor because they want to make sure that he goes nowhere near the alleged victim in the case. And I say alleged, I'm a defense attorney. State would say victim, and that's how it's going to be written up on the reports, not to go anywhere near the victim. Psychological evaluation, follow-up treatment, anger management, GPS stays the entire time. On the felonies, no convictions, so the client is not a convicted felon. We're able to maintain a withhold of adjudication. Very difficult to do on these kinds of charges, especially domestic violence cases. He is adjudicated on the misdemeanor, but he had previous adjudication on a misdemeanor case, so nothing changed. He wasn't penalized in any way for it. If he violates his probation over the next year of community control or 5 years probation, he's facing 21 years of Florida State Prison, but now it's in his hands. So we think that we did a solid job. Obviously, in my mind, I wanted to get the aggravated stalking dismissed outright, and I wanted to get the burglary dismissed outright. Although my compromise was, the misdemeanor on those. I got the trespass. They wouldn't do that on the third degree stalking, but it's a withhold. He's not a convicted felon. And the threats, the odds of winning were so small, it wasn't worth the risk, but the client always makes that decision. I never make that decision for a client. My job is to give you options, to do everything I can. And like I tell every single client, my first thing, rule number one is to do everything you can as a defense attorney to keep your client out of prison. That's number one. Number two, second most important thing is to keep your client from becoming a convicted felon, to be convicted of the crime. And we were able to do that. The other things, the ancillary things, having house arrest, having the guns forfeited, having a psychological evaluation and any follow-up treatment, those come after the fact, and quite frankly, to me, they're not as important. Other people may have different views on that, But those are my views. Anyway, folks, I wanted to share with you a case that's been very important to me. My whole story, even when the state offered on the record today in court, the judge said, Mr. Foley, now explain why I would accept that. Because even though we negotiated it, right, the state and the defense negotiated the sentence, the judge can accept it or say no. And this particular judge is known for saying, yeah, I'm not going to accept that. I need prison time. So then I was placed on the spot. I was up at the podium, and I had to do a miniaturized version of a closing argument and talk about a man who was depressed, who had alcohol problems, had some anger problems. But really, it was the depression mixed with the alcohol at the time, which led him to make that threat. You know, we argued that it was an idle threat. He had no intention, because he additionally, in the same text messages during that night, he also said, you know, I love you and I would never harm you. So, but that wasn't enough to hold hold our hats on in front of a jury. More than likely, he would have been convicted on that charge. And, you know, we estimated he probably would have done 5 to 10 years of prison on that. Just on the score sheet, he scored prison, even with the charges reduced. You know, he scored just under 2 years. Remember, he was sitting in custody that whole 15 months roughly. So it's not like he didn't do, he did some jail time, but on a life felony, a lot of times the judge does not let you out because you're a risk. You're a danger to the community, and especially on a domestic violence case. So I've had, probably a dozen or so life felonies. First one that anyone ever sat in custody while the case was going. But this was a long case, lots of depositions of police, civilians, juveniles, getting CAD reports, 911 reports, looking for cameras, hiring investigators. So much went into this case, doing these focus groups with another attorney from out of state to come in and help. We really put the effort in. Everyone around me says that it was an outstanding result. I think it was a good result. I wish I would have got those 2 charges outright dismissed. But the sentencing probably would have been the same. It just would have been, what was on the actual score sheet and what was part of the disposition, meaning the final paperwork. But anyway, overall, I'm happy. I'm going to go in, look in the mirror this evening. I'm going to look in the mirror tomorrow morning and know that I gave my client the absolute best that I had. I'm attorney Roger P. Foley. I handle criminal matters. If you have a question, feel free to call me. Thanks.